Thank you, everybody, for being here. My name is Ahmed Gaya. I run a thing called the Climate Justice Collaborative at the National Partnership for New Americans, which is a coalition of 71 state and local immigrant rights organizations here in the U.S. And I also coordinate the Environmental Law Working Group with Detention Watch Network, specifically supporting connecting environmental law groups and attorneys to immigrant rights organizations fighting detention centers in this particular moment. So this is a really timely topic where things are happening right now. I actually got a number of requests for assistance yesterday. So I just want to name, I'm really excited that you're all in the room, that we have kind of two goals of this workshop. So one goal, obviously, is to educate and inform folks about how folks are using tools at the federal, state, and local level under environmental law to challenge the unprecedented and rapid expansion of detention and deportation infrastructure being constructed here in the United States. The second is to actively recruit folks into this work. There are significantly more site fights and requests for help on the ground than we currently have capacity from some of the generous support of larger and smaller environmental groups who have stepped into this work. And so just want to be very explicit that if you are a law student, if you are an attorney, if you are connected to those folks, and you are inspired by the kind of legacy of work and specific examples that we present today, definitely encourage you to connect with us after the panel. And there are some formal structures like the working group, a warehouse-specific legal call that Anne's team helps coordinate that we can plug you into. That's definitely a very needed thing at this time. So just want to give that context. And then just also a very kind of broad, Anne is going to share in a moment a little bit more of a kind of snapshot look at what the expansion of detention under the second Trump administration looks like, what we've seen and what we're seeing right now. But just a context to this work, there's obviously been a history over many decades of folks utilizing federal and state and local, from zoning ordinances to federal laws like NEPA or Clean Water Act to challenge state, local, and federal detention facilities, whether they be Bureau of Prisons, county jails, or immigrant rights, or immigrant detention centers. And that's a legacy that's existed. Under the moment right now, we're in kind of an unprecedented expansion of detention infrastructure around the country. And so in 2024, after the election of Trump, a couple of us came together and were like, hey, there is this unprecedented expansion that is about to happen. There needs to be a similar ramp up of resources to support the folks on the ground that are going to be facing more fights than we've ever seen simultaneously, to use every tool at their disposal to fight them. And so NPNA, Detention Watch Network, NRDC, a few other folks formed this Environmental Law Working Group, which is a coordinating space to support connecting both resources to immigrant rights groups, as well as connecting directly kind of environmental lawyers, like I said, environmental law groups and others, to consult directly with those folks on the ground. That's expanded a bit as we've seen some states' attorney generals, some local municipalities also get involved in this litigation and explore using these tools. So there are more folks who are asking for that help. And that working group's been operating for about the last year. And then I help facilitate it. I am not an attorney, I'm an organizer. So it's been an interesting role to be in, building out this capacity. And the main thing I've seen is that, historically, the way these fights have happened have been through folks having personal relationships. There aren't a lot of formal structures where immigrant rights advocates, specifically on the legal side, are connected with environmental law experts in these conversations. So it's often been, there's a detention center in a particular area, someone at a local environmental group has a relationship with somebody at an environmental law organization, calls them up and says, hey, can you help? And that's how folks have been put in a very ad hoc basis. And so our hope is that as we're seeing this kind of systemic number of very harebrained projects that the administration is coming up with for these massive expansions, we can move from those ad hoc supports into a more systemic connection of folks, and you systematize it a bit so that folks are not duplicating resources, so that we can meet the challenge of the moment. And as Anne and Michelle and Peniotti and Meriel are going to cover, we don't see these environmental laws as like a silver bullet on killing these projects, but we're in a moment in which kind of every tool we have available in our toolbox to delay, to slow down, to force them to comply with everything they're failing to comply with gives us power and ability to bring more leverage that results in them being defeated. We have seen that successfully in a number of places, both historically and in this moment. So that's kind of the broad context I'm going to give. I'm going to just take questions at the end, not say a lot more. I'm really excited about the folks that we have on the panel. I'll let them introduce themselves more thoroughly, but I'll just say that to start out, Anne from the National Immigration Project, NLG, is going to cover the overall kind of, like I said, the snapshot of detention as it currently stands, immigrant detention as it currently stands under Trump 2.0. And then Michelle Fein is a private practice attorney with Fein Law, who's been really helping coordinate some of those resources with the working group. Really deeply appreciate her support there over the last year. Is going to go over in broad strokes some of the cases that we've seen been brought, the legal arguments and claims that folks have used or are considering using. And then Peniotti is the founder of Fighting Toxic Prisons, a number of other projects using these tools more broadly across the prison industrial context. We'll give a little bit of historical context of some of the fights that we've seen over the last 10 years using these tools on Bureau of Prisons and some other targets. Lastly, Meriel from Crag Law will share about the active case here in Oregon with the Newport proposal to convert the Newport Coast Guard facility into an immigrant detention facility in the current litigation that's going on right now, really digging into a case study that's happening here in Oregon. So that's going to be the broad structure of this. Then we'll take a very brief moderated conversation and try much of our time as possible with questions from y'all. Sound good?
Great.
Awesome. Well, with that, I'll pass it over to Anne.
I'll come over here so that I can
I can do this.
Is that okay?
Yeah, you can just tell me next slide.
Awesome. Cool. So, hello everybody. This is my first one of these conferences. I'm really glad to be here. I'm an immigration lawyer. I work at the National Immigration Project. We're a national organization. I happen to be based in Portland, which is why it was very, very easy for me to drive down here. I'm really grateful for this space because we need help creating the connective tissue between immigration advocates and environmental advocates and lawyers, especially at this time. And so glad that you all could be here and find a space in this room. So the National Immigration Project is a membership-based organization. Our members really run the gamut from other lawyers to organizers to folks that are affected by the immigration system. And we've been doing this work for a long time. Our work really focuses on trying to abolish detention and go after detention centers writ large. We are, because of that focus, we really do a lot of work in the southeast of the United States, which is, as I will talk about in a second, where there's just a huge concentration of detention centers. But we're, like I said, national, and we have a team of like 30 folks, and we're everywhere in the US. Which is great. It allows us to connect in when there's a site fight that we need to connect into. So yeah, it's, I'll promise to be brief about the context. It's going to be a little bit heavy, but then we're going to get into how we're fighting and sometimes winning on this issue. So as folks have probably seen, because it's really been hard to miss if you've been reading the news, it's been a brutal 14 months, to be honest. I think folks have seen just the absolute battering that ICE and CBP at this point have taken on American communities, whether it's Minneapolis, Los Angeles, Chicago, Washington, D.C., and many communities, including ours in between. The percent increase in interior enforcement and deportation of community members has been 600% in the last 14 months. So just tremendous. If I can just put this into context and sort of like explain the difference and what's changed, the Biden administration, we can really think about having enforced immigration law at the border. This administration, second Trump administration, is doing that in the interior. They're doing that within our communities, and that's why it's being felt in this way by, a lot of people in the room probably. So I think we'll go to the next slide and let's get into it. Great. So a bit on basics. So immigration detention centers, like I said, are everywhere. They take many shapes. Sometimes they're in local jails, sometimes they're in state prisons, sometimes they're like the detention center up in Tacoma, Washington, which is owned by a private corporation called Gaya. They're everywhere, right? They're in 50 states, they're in the territories, they're at this point in Guantanamo Bay too, as y'all might have read about. So it's a huge network that spans the whole country. And there's some things that really, some characteristics that detention centers really share, no matter whether they're in a local jail or if they're a tent in the desert in El Paso. So usually they're pretty remote. They're pretty far away, usually from help. And secondly, they are carceral settings. I don't know how to describe that. It's just like they look and feel like a jail or a prison, even though immigration is civil in nature, right? It's not meant to be criminal detention. So ICE really chooses, I guess is what I'm trying to say, to detain folks. It's a choice that they're making. We saw a different choice made by prior administrations, and now we're seeing them choose to detain folks. There's so much data out there that shows that when immigrant communities and individuals are released into the community and told, you need to do X, Y, Z, folks comply by and large, right? So there's not really a reason to be doing this. The reason it's happening is because of profit motive and the toxic politics of immigration at this point. So 86% of folks who are in ICE custody now are held in for-profit detention facilities. Right? So let's go to the next slide, and I'll show you. Sorry that this is really pretty small font, but what I'm trying to put across here is that ICE owns, at this point of the total number of ICE facilities in the country, they actually own a really small sliver. They own 5. And the rest are local jails, prisons, facilities that are owned and operated by private corporations, yeah? So, and the reason I'm pointing this out right now is because ICE is trying to change that, right? They're trying to buy up a lot of different warehouses and detain folks in them. So the nature of immigrant detention at this moment is really undergoing a huge flux. And that's where a lot of the environmental interventions that we're going to talk about sort of come in, because immigration detention is really splitting at the seams. There's so many folks that ICE has detained and CBP has detained and put into ICE detention that they kind of run out of places to put folks. Let's go to the next slide. Thanks. So I hope folks can see this. This is showing the number of individuals who are currently in ICE detention as of this year. So as you can see, in, I think it was January when the 73,000 number was taken. In January, there were 73,000 folks that were in detention. When Trump took office, the January before that, it was somewhere hovering around 40,000. And if you look at the line at the very top, that's this administration's goal of 107,000 plus in detention by the end of this year. Yeah, so really exponential growth. The way that they've managed to do this year, go 3,000 over and often more, is by putting folks into facilities that are, with cells that have not enough beds for folks. We litigated a case, when we're still in litigation, about a case that involves ICE putting folks into rooms that are supposed to be used for 48 hours max, but people are being held there for weeks on end, months on end. And they're doing this by putting people into facilities that are sort of separated by chain link fence, right? Lots of, where there's, in the El Paso example that I'm thinking about, just a huge measles outbreak that's broken out. So that's how they're getting there. And that's where they want to get there. Let's go to the next slide. Let's talk about funding, because this is really what's made this happen. This is what's made this work for them. So last July, a bill was signed into law called the One Big Beautiful Bill Act, HR 1, that gave ICE $15 billion per year to detain folks. That's not like the DHS budget. That's the budget to detain folks by ICE, right? So that is actually kind of like not the biggest subset of funding. And that funding kind of goes year by year through fiscal year 2029. To put that into perspective, because I mean, I'm not an economist and it's hard for me to think about numbers in this way, it was 3.4 billion the last year. So you do the math on how much it's grown. Let's go to the next slide. Great. And as I was saying earlier, ICE has really kind of run out of places to put folks. The map shows the use of county jails to detain additional people. It's not a map of detention centers, but to give you an idea, ICE has signed 104 new contracts with local jails, with state jails, state facilities and such since the inauguration to figure out ways to detain additional people. The way that they've managed to put so many people in detention is really through, and I'm sure y'all know this, a huge number of ICE arrests on the street, right? 11 times what it used to be, what it had been last year. A lot more arrests from criminal custody. I don't just mean folks that have a record. I mean that in places like Florida and elsewhere, people are just getting pulled out of their cars because they're driving while brown most often. And so just a huge amount. And then also, ICE is not discretionarily releasing people as they once did, right? So they're kind of just keeping everybody until that person gives up and goes. I won't get into it because we don't have time, but asylum is kind of dead right now, and people are not able to get their day in court and immigration at this point. So really, they're just kind of trying to keep as many people in detention as they can so that their numbers can, probably be paraded at midterms with their folks. And then also trying to motivate as many people as possible to self-report, right, without a chance at a day in court. So the reason I'm laying this out in this way, let's go to the next slide, is to get to talking about the big changes that the immigration infrastructure is undergoing right now. So they've run out of places to really put people. They've contracted with everywhere that they possibly could. And now they're doing something new, which is build new, what they call soft-sided detention facilities, which really just means tents. They're like white, extremely large tents. Some of you might have seen photos of these that are like temporary facilities that they can put up rather quickly and detain a lot of folks there. So an example of this, and where a lot of folks from Minneapolis got sent to, is Camp East Montana in El Paso. This facility can hold up to 5,000 people. Like I mentioned, the cells are kind of separated by chain link fence, so there's not really any kind of separation, which is bad for many reasons, including health. I think colleagues are going to talk about Alcatraz in Florida, which is owned and operated by the state of Florida, even though immigration is a federal issue. Anyhow, that's a novel thing. A lot of folks are hurting. There have been a lot of deaths, 11 this year, 3 in Camp East Montana. And I think one number that kind of impressed me when I first saw it and sort of, I think, showed a lot of folks the level of need within that facility is that within the first 15 weeks of that facility opening, there were 90 calls into 911 for various things, right? So just incredibly dangerous situations. Let's go to the next slide. Which gets us to warehouses. Some of you might have seen this. It came out, I think, over the holidays, and at first I wasn't sure whether I should believe it or not. But of course it's real. So ICE has released what they call a detention re-engineering initiative. So what they plan to do is to, they're basically impressed by the Amazon model. That's like in their words, not mine. and sort of like the idea of having a hub and spoke model, where you have at the hub these absolutely mega detention facilities, like the one that they're trying to open that is pictured here in Social Circle, Georgia. And those would hold up to 10,000 folks. And then the spoke part of it is smaller detention facilities that hold up to 1,500 that are also in warehouses that are for product. And they're planning to have 34 of these by the end of the year, right? So the environmental and zoning and all of these fights that we are sort of bringing to the government really come in, as my co-presenters are going to talk about, because these are new facilities, right? They're warehouses that have never been used for this, and they need just tremendous renovations to be able to get there. This is a schema of one of the facilities to just give you an idea what their plan is. I think that they have one emergency exit for 10,000 people, so to give you an idea. Let's go to the next slide. Yeah. And this is just to give folks an idea. This map probably changed this week because I heard that they succeeded. I succeeded in buying, I think, the Utah facility, one of the facilities. But this is to give you an idea. The sales that have been canceled are in green. Those have been fights that have been won by a lot of folks in the room. The yellows are the prospective sites. So sites that they're planning to establish. The red are the ones that are bought by ICE. That includes one in Georgia that was just pictured in the last slide. That is one of the mega ones that they're pretty far along. My colleagues are going to talk about Maryland facility that has just gotten a stop work order, which is awesome. And then the orange is conversion in progress. So just to give you an idea of the geography of it all. And now I'm going to pass it off to Michelle, who's going to bring us up, because I just brought us down. Sorry about that.
And before you pass it off,
Yep.
one thing we were talking about on the phone the other day that I'd love for you to share here is just the framing that they've been through, it's only been a year, but
Yeah.
they've been through multiple
Yeah.
different kind of nationwide schemes
Yes.
that they've tried.
Yeah.
I don't know if you want to share a little
Yeah,
bit just
yeah.
about that
Of course.
context and how we should think of the
Yeah.
warehouses in that
Of
context.
course, yeah. So, like Ahmed says, we spent the last 14 months fighting different schemes that ICE has had to increase capacity, right? The warehouses, like they're suggesting, are just kind of their latest attempt to grow capacity. We've worked to defeat the previous ones, and then sometimes we've won, right? As a community of advocates. This is just kind of their latest BS, right? But they're getting really close to opening some of these facilities, and it would be just the most horrific thing that I've seen in my years of practicing. And so they're really worth fighting. I want to also add that if you do environmental work and you don't follow immigration every day, and you see a headline that says warehouse plan has been defeated, which will be great, don't think that we've won, because they're going to move into the next plan that is going to be equally or more horrendous. What we see in the last 14 months has just been more and more cruel kind of plans, right? And just more and more horrific conditions. And so plug into the work if you have capacity, or tell your colleagues that we need help. And yeah, thank you for letting me come, and I'll pass it on.
I'm a practitioner, solo practitioner, that I work with other environmental attorneys to file traditional citizen suit litigation under the big federal laws. And I used to be a litigator at NRDC. And while at NRDC, I sort of, then and before, even before law school, I was really interested in the intersection of environmental law with civil rights law and protections of challenging historically old and decrepit prisons and inhumane conditions, and just using environmental law creatively to do those things. So I've been lucky to do these types of investigations in the past, and was really excited to tap into the working group last year and work with some amazing advocates like Ahmed and Anne and everyone here and elsewhere. But I'm going to very quickly lay out the broad strokes of some cases and claims that people are considering across the country right now, focusing on Florida and Maryland, and then some other just southern and western areas. I am not litigating these cases, so I have to give that disclaimer right up front. I'm following these cases as a litigator, but I'm not litigating them, and so obviously take everything I say with a grain of salt. This is all my view of the cases and my conversations with folks that are working on these claims. But I think what's been a real focus for advocates out there, and this is all just to inspire you all to, in your locations, think creatively and have fun, think through all of the various federal, state, and local laws you can use to challenge detention centers that pop up wherever you are working or living. I think the big focus is looking to make easy administrative claims based on clearly unlawful mistakes, right? So the big one has been the failure to conduct or even document any NEPA review. And that's a pretty clear one that has formed the basis of a couple of the cases I'm going to talk about now, and a couple that aren't even going to be reviewed here. So that, I guess next slide, the first example of that pretty clear, you have like a pretty strong legal violation, and so what ends up needing to happen is a lot of factual development about the harm on the ground, and what's going to happen when these detention centers get built or expanded or purchased, warehouses get purchased and converted into places where they're supposed to house thousands of people when the warehouse has no services or connections to be able to do so. And one example of a really successful case that has since gotten bogged down, of course, in some specifics, is the Friends of the Everglades case, also known as the Alligator Alcatraz case, which I'm sure many of you heard about last summer, which kind of made national news last summer when Trump went down there to talk about it. But basically, the Friends of the Everglades Center for Biological Diversity and the Tuskegee Tribe of Indians of Florida, they challenged the construction of an expansion of basically an airstrip into a detention center in the Everglades. It is a straight NEPA APA case, failure to follow NEPA, failure to conduct any NEPA analysis or complete an EIS to do the required environmental review, and unlawful and arbitrary and capricious conduct in failing to do that. There was also an ultra vires claim in there against the state for constructing the facility without any authority to do that, and without consultation with local governments and the tribe. The tribe intervened as well in the case and brought an additional claim under the National Historic Preservation Act, which requires consultation, a very detailed consultation process with Native American tribes to preserve their historic and cultural and spiritual resources on the site. And the tribe alleged significant harms to their food and water supply. The environmental organizations pulled together an immense amount, in months, pulled together an incredible amount of evidence of on-the-ground impacts to species and to that sensitive area in the Everglades from the expansion and the detention of individuals there. Because formerly it was like a training airstrip, and a very small one. And they got a huge win last August, and they got a preliminary injunction ordering that construction stop on the facility and that the facility be wound down. And unfortunately, it was very quickly, a couple weeks later, that decision and that injunction was paused by the 11th Circuit and has since been sort of delayed. Resolution of what will happen with that injunction has been delayed since. The 11th Circuit said that no federal dollars had yet been expended on the construction or use of the facility, even though there was a lot of evidence of federal statements and commitments of funding. In the end, the government was able to sort of obscure, the federal government was able to obscure their involvement with the facility, and the state was taking a lot of initiative to build and to commit resources up front at least. So because there was that ambiguity in whether it was truly a federal action, which was the trigger for NEPA, the 11th Circuit was able to put a pause on the injunction. But it's still an incredible win on a really high profile case, and it's still being argue right now what is the true federal involvement here. Because now the state is saying the feds are actually never going to reimburse them for construction. And then there's some debates in the 11th Circuit about whether, if that's true, the state even had authority to construct a federal detention center without federal approval, which seems, it should be axiomatic that there is federal involvement here. But the case that, just one example of where a case where it's just a complicating factor, a local complicating factor in this case that will not likely be present in warehouse challenges where the federal government is directly buying and contracting for the construction and development of those warehouses. Another case I wanted to highlight was the Maryland case. A lot of cool stuff coming out of Maryland. There's a preliminary injunction and a class action case asserting inhumane conditions at Baltimore holding facilities. But the case I really wanted to highlight, and a couple other cases, but to move quickly, I want to highlight just 2 days ago, there was an ex-party TRO, temporary restraining order, issued in Maryland by a judge. The state of Maryland had filed a case against DHS to stop the conversion of a warehouse in Williamsport, Maryland, into a detention facility without complying with NEPA. Same claims, NEPA, APA claims. And here, in contrast, you have a pretty clear commitment of federal resources and a pretty clear major federal action, again, the NEPA trigger. So you have 2 days after, there was no NEPA review conducted, there was a notice posted on the public website or on the DHS website saying that they had done some undisclosed NEPA review, and some folks who were watching had submitted comments, but then the comment period closed, or the day after, DHS signed an agreement to reconstruct the facility, or to convert the facility from a warehouse into a detention center, and the agreement was to proceed, it was a $100 million contract to proceed for 2 months, basically, to take a very short amount of time to convert this into a detention facility. So with those facts, the court felt comfortable issuing an ex parte TRO, meaning the government didn't even have a chance to respond. And this all happened really quickly, and the motion was filed and granted within a day. So just another amazing successful win, and an example of where if you have a really strong legal violation, a sympathetic court, and strong on the ground evidence of harm, here the state said there would be a huge drain on the sewage system, risks of overflows, pollution to sensitive waterways, species and ecosystem harm, sediment runoff, same in Everglades, just immeasurable harm pulled together by these attorneys, and in this case the state very quickly, and presented to the judge that they got a great result very quickly. And then just thinking about there's some other, NEPA has obviously been the big challenge because of that pretty clear legal violation. They're just not doing any NEPA analyses. There are other laws to think about here, especially in the absence of any federal enforcement here, or any federal compliance with laws, or even robust state enforcement if you're in a state that is not Maryland, or states that are, welcoming these facilities. There's really probably an opportunity to use land use and water regimes and just bringing these fights to sort of the local government level if you can. There are obviously risks that you can still be preempted later on, but those are very powerful fights as well. And some groups are looking at, for example, state groundwater regimes, especially out west. Water is a huge galvanizing issue, of course. And there are state-specific, depending on where you are. Many of you are probably familiar in your own state with them, different water districts or groundwater regimes, because the surface water is typically allocated out already across the West. So in order to gain access to the groundwater that these facilities might need, they would have to either apply to the state water district or go through whatever state-specific process they need to, either a water rights proposal or some other application to get the water they need, and that's just typically not happening. And folks are looking into those types of claims as well. In that type of a case, you might have you might need the water district to file, or a water district voter, for example, and that could be a landowner or farmer. So another really interesting and beneficial aspect of pursuing this type of a claim is that you would get support from folks who might traditionally not support this type of a case, but once their water is threatened, a farmer or landowner, they will very much line up to oppose that facility. And then there's some looking into land use, zoning issues, and public nuisance claims in various places, east and west. I think all of these are in, I don't have any examples for you right now of specific cases that have been filed, but I know in talking to advocates looking at these claims, they're looking at things like special harms to properties adjacent to these facilities, roads being built, more waste and sewage, taxes and emergency services, just thinking through the local and special characteristics of that area where the facility is being built, and also special characteristics of the location generally, like states with large coasts that might have very specific coastal rules, and that my colleague Meriel is going to talk about later in her presentation about the Oregon case. There might be special coastal rules or surface water rules or surface groundwater related rules in states that have special regimes to protect coastal areas like Florida, Louisiana, and Oregon. So yeah, that's a really quick survey of things that are being considered right now by advocates, and again, just focusing on local special characteristics of the area and major federal investment involvement to sort of avoid the pitfalls that the Everglades case fell into. And as I had already mentioned, warehouses might be the exact perfect mix of those issues. And finally, I just want to bring up programmatic. Advocates, including myself and others, have been thinking about the idea of a programmatic challenge. Oh yeah, thanks. This is great. Please do proceed forward. This is just, again, some factors to consider when you're looking at site challenges where you have the ability to analyze this and to think creatively about these laws. And these are just some of the first questions that you might want to ask yourself when you're doing that. But yeah, I was just going to mention quickly, programmatic NEPA challenges are difficult to bring, but we clearly have a program expansion here, at least of the warehouses, the push to build and to purchase and to build out warehousing of folks in immigration detention. So I know groups are thinking about how to bring that together in a programmatic challenge. And there are a lot of issues that can attend a programmatic challenge, but the powerful thing is if you can convince a court that there is a program that is coherent, that has failed to comply with the NEPA review, then you could potentially stop the whole program itself, which is one of the advantages of that. I just wanted to highlight that. We can't really get into the details of those types of challenges, but if you want to know about that, there has been a lot of analysis of that type of claim, and groups, I know a lot of major groups are looking at it as well. That's all I have to say. I'm going to pass it on to who's next.
Ahmed is next. And just on the programmatic challenges, one thing, Michelle, and then it's important to note that those are not mutually exclusive to the individual site types, which is one question a bunch of folks have asked us. I'll pass it to Fein to give a little bit more context and how this has been used historically in other prison situations.
Cool. Thank you, Michelle and Ann. PIELC26. I have worked full-time in immigrant rights, prisoner rights, and environmental organizations and movements for the past 20 years, including the Florida Immigrant Coalition and currently the Maine Immigrant Rights Coalition, as well as the Earth First Journal, the Center for Biological Diversity, and Greenpeace in the past. In 2014, I co-founded the Prison Ecology Project along with Paul Wright from Prison Legal News, and we actually kicked it off at a panel here talking about prisons and environmental justice in 2015. That developed into the Campaign to Fight Toxic Prisons, which went on to host annual convergences of hundreds of people like this around the country at different venues, bringing together prisoner rights and environmental justice advocates and abolitionists to talk about these sorts of challenges. So I'll let this Venn diagram speak for itself. But I'm going to talk a little bit about some of those examples and things that we've done in tandem with legal challenges as community organizers. So you can, next slide. The main thing I want you to take home with you today is this, that we can fight and win, and that you know, as I tell my kid when we're practicing soccer, that you miss every shot you don't take. Next. So, you know, there's not, next one. Oh yeah, next one, sorry. So this is a kind of foundation of environmental justice and abolitionist values that both seek to address the roots of a problem and then transform society accordingly. If you're not familiar with those concepts, I really encourage people to look into the robust academic research and as well as grassroots community organizing that happens under those banners. Next. You know, there's not a single formula for winning environmental or abolitionist campaigns, but these are three concepts that I think are three ingredients, you know, that tend to make a reliable and palatable dish for fighting campaigns on the ground. And I want to highlight the third one, strategic and ambitious litigation, as I think we heard some great examples of the last two speakers, and we're going to hear a little more from the final speaker. I wanted to bring this example up because, in particular, I think the quote at the bottom here, I'll read it, by Buddy Vines, really sums it up from this. This is a review of a prison fight in Alabama on the Black Warrior River. Rest assured that if any of us was dumping raw sewage into the river, we would be heavily fined and locked up in the very prison we're discussing, said a local resident who was a lifelong property owner and local opponent of the sewage damage being done to the river by the prison there. Next. I put this quote up here mostly because I wanted to highlight that Sierra Club. You know, I think maybe some years ago, if you would have considered who was going to like lead the charge or be talking about this issue, it felt like a stretch. But this was an article in a printed magazine. It went out to 2 million members, and originally the article was headlined "A Factory Farm for Humans." Maybe someone complained about that because when they put it online, they changed the headline of the article. But I do think it touches on the foundation of what was being talked about, like water and sewage is the result of piling people, in some cases the size of a city, a small town, into a single building. And Paul Wright here, I think, also summed it up. You know, you start looking at criminal justice through an environmental lens, a whole new world opens up around you know, these environmental justice issues. So I want to mention a couple tools that we developed and are available for folks. One of them being the Toxic Prisons Mapping Project, which came out of years of research and collaborative effort to document this. Next. And the trends that were being seen. So you can track this down as an interactive map, finding it online. The red dots represent states with prisons, jails, and federal facilities. And these are some of the criteria you can search under, looking at what might be the impact. So if you're looking to back up your local environmental or immigrant rights group who's considering a site fight against a new facility, this tool I think can be really valuable in seeing some of the potential harms in the area. And we can track it down. Am I searching it? This next one, unfortunately, it's not how the slide should have looked, but when I looked it up yesterday, the site is offline. Some of you might know, if you do environmental research, the EPA used to have a thing called EJ Screen. It's no longer online, but some awesome folks working on data maintenance and protection put the site back up, like a parallel site of it. And unfortunately, although it does generally work and it's still a valuable tool, we had one prison layer as one of the landmarks on the map for EJ Screen through like a administrative fight with the Office of Environmental Justice in 2017. For some reason, it's not working. So I just sent an email to the folks in this data project saying, please figure out why we can't see this, because it's an important tool, especially the jails. If you're in a place where there's a local jail fight, it's likely the jail is going to be should be on this map, and then you can track climate impacts, flood risks, and other Superfund issues. I want to give this little shout out to my friend Judah Shep, who is referencing here an important case, one of the kind of foundations of the environmental justice and prison abolition nexus, which was the kangaroo rat versus the Delano prison in California. They won years of delays. In fact, when they did finally build the prison, but at the ribbon cutting ceremony, the head state official said, "This is probably the last prison we'll build in California," as basically a nod that the advocates had done their work so well that they didn't want to go through the headache of trying. And we built a model off that fight to oppose a prison in Letcher County, Kentucky, a federal prison. We filed a lawsuit against it with 21 prisoners as the primary plaintiffs. It was a NEPA complaint, noting although we did highlight a ton of environmental issues in Central Appalachia there, the case was brought with an administrative concern that the prisoners who were very much stakeholders in the outcome didn't have access as they were supposed to be able to review the NEPA process. So just noting the technical aspects that the NEPA challenge includes beyond just environmental impact. Next. So that prison fight that's still going on, although it was, in 2019 it was withdrawn. In 2022 it came back up for development. A local organizing crew in the interim bought a chunk of land right in the middle of the proposed prison site and are now fighting the new proposal as owners of a piece of land in that footprint. So these are just a couple examples that I'm going to run through of other fights. In Alabama, there was a very robust legal challenge to a plan for prison expansion, which included economic arguments about the approvals that came from ARPA funds. And they had some success in making headlines, generating some delays in space and time for organizing. This one was in northern Florida, and it was a site fight on whether or not the jail should be moved from a flood zone to an EPA Superfund site. And so these are the kind of, it's a bit of a strategic conundrum, but just to show how frequent the environmental factors are present and sometimes multiple. Here was another one where an adjacent toxic site, which is the case often at existing prisons and jails, probably some of these proposed warehouses. There was a phosphate mine waste storage area that blew out and flooded the entire bottom floor of the Manatee County Jail. This was a fight against one of the facilities that was on the map in the last presentation, Glades County, now one of the major holding sites, which had a series of environmental health concerns along with abuse and human rights violations. Next, we succeeded in shutting this one down in 2022. They moved out essentially they canceled the ICE contract, moved out all the detainees, which was cool. The next, until 2 years later, when they reopened it, even though it still didn't meet the standards for holding people. So that's been the reality that we're currently living under at the moment. And there are many more, but in the case you're interested, I just want to include these case citations, especially for you all out there who are trying to get your CLE credits. I'm not a lawyer, I didn't mention that, but I do know that there are some requirements that you have to pretend like you're paying attention. So write down the case citations and get your CLE credits so you can help us fight these prisons in the future.
I'll close out this part of it with Meriel sharing about the organizations. One thing I'll just note, and one of the reasons why it's really important that Penny OT, I wanted him to go through all of those local prison fights, is just once again, as Anne pointed out, many of the detainees in immigrant detention are being held in contracts with local jails. There are a lot of fights around those contract renewals for detention centers. It's not just the big high-profile warehouse fights that we're recruiting support in, but also some of these less flashy, less sexy fighting around a contract renewal for a private prison company or a county jail, in which many of these claims can also be made.
Hi everyone, I'm cleanup here. I'm Meriel from Crag in Portland, and we are a nonprofit environmental law firm. We do work up and down the West Coast. We're pretty broad in the stuff that we do, so we cover public lands and climate and environmental justice and land use. And so our involvement in this work is sort of, it makes sense for us, but it was a little surprising because this wasn't something where we had been involved in this amazing coalition before, but we hope to be involved now. So thanks for including us. But we got involved because of the site on the coast, but I just wanted to, before we get to that, something that worked out for us was we do local land use, and then we also do federal land. So most of my practice is like federal lands litigation, NEPA, and some of the other laws that Michelle cited, but I also do local land use, and so do a lot of my colleagues who are here. And so we had been involved a little bit on the Portland ICE facility, which is small processing facility. Some of you maybe have protested there, but it's kind of a transfer spot for folks before they go to Tacoma. And there's obviously been a lot of protests there, and there are some land use issues with that site because it's privately owned, and there are some conditions on the permit that site has. And so we have been sort of looking at that site and looking at some land use issues. And we also had the pleasure of litigating a warehouse issue, not a detention center warehouse, just a warehouse. Also in Portland. So we were kind of already touching some of these issues, plus I do a lot of NEPA litigation. And then I guess the other piece of that, there's a fourth big piece, which is we have a coastal law project. And so we work with some clients on the Oregon coast, Surfrider, and Oregon Shores. And so we do a lot of coastal litigation and involved in policy stuff on the coast as well. So when this issue with Newport came up, it sort of was an interesting intersection of a lot of our work. So if some of you are probably from Oregon, so you might have followed this, but there was an interesting situation. The Newport Airport, which was just a municipal airport, but also housed a Coast Guard helicopter. In the fall of 2025, all of a sudden that helicopter disappeared, and it was the primary safety rescue helicopter for the coastal community there in Newport, primarily the fishing community and also recreational community. And so that helicopter, if you've ever spent time in like Lincoln City or Newport or any of those towns, you probably see it. It's always going overhead. I mean, you can see it when you're on the beach. And that's kind of the lifeline for folks that recreate and work in the ocean there. And so that helicopter disappeared. And that was a big problem for those communities. And so immediately some lawsuits were filed to bring that helicopter back. So it was moved from Newport to North Bend, further south on the coast. And so there was a case filed, and there had previously been some issues with that helicopter being moved like 10 years ago, and there was some actually federal legislation passed, thanks to I think Oregon senators, that put some sideboards in on when that helicopter can be moved and required some process before it can be moved. And so the fishing community and the county, Lincoln County, filed a lawsuit and filed for a temporary restraining order to bring the helicopter back. And so that kind of started this investigation into what was going on with the helicopter and why it was getting moved. And they got an injunction to bring the helicopter back. And what was interesting about that claim that they brought was it was brought as an APA claim under 706 for arbitrary and capricious agency or unlawful agency action because of this federal law that had been passed. So that set up the initial case that was going on. And then some other interesting things happened, and this This is really unusual for a normal APA environmental case. It wasn't even environmental yet, or even an APA case in general. But I think because of who these parties were, the state of Oregon intervened or filed their own case around the helicopter. And because they needed to figure out what was going on with the helicopter, they started discovery immediately in that case. It was before Judge Aiken in Eugene, here in Eugene. And the fishermen, the fisherman plaintiff was called the Newport Fishermen Wives Association, and they started doing discovery on the federal defendants, on the Coast Guard, using their APA claims, which if anybody here does APA practice, you don't normally get discovery in an APA case because it's based on the administrative record. So you aren't really allowed to bring in any evidence that's outside of what was before the agency when it made its decision. But they sort of skipped over all that in this case and started taking depositions of the Coast Guard folks. And so there's a picture of the deposition that went in. So they basically just got a TRO from Judge Aiken, and then she set up a briefing schedule for preliminary injunction. And in that couple of weeks between when they entered the TRO that forced the helicopter to come back and the preliminary injunction, they made this Coast Guard guy sit for this deposition in Captain Reinhold sit for a deposition, and they were able to ask him a bunch of questions about what was going on with the helicopter. And in the process of that deposition, he admitted that they were moving it because they were going to start using the airport as an ICE detention facility. And so he didn't, say too much about it, but what happened was at the same time that happened, there was starting to be a lot of movement in the Newport community and rumors and information circulating and things popping up online about federal contractors coming into the community and looking for sites and workforce development and health services and transportation and water supply and waste management, all towards the idea of building basically the soft side tent city of a detention center at the airport. So these things were kind of converging together really quickly, and this is all in like November, December of 2025, this past year. So after that, there was that admission in the deposition from the Coast Guard captain, and then some other, there was some back and forth between the city of Newport and the Coast Guard, and then, more evidence was gathered online. The state of Oregon and the city of Newport the state of Oregon amended its complaint to add environmental claims to their case against ICE, and they added Christie Nome and they added ICE. I think they had the Coast Guard and DHS, but they sort of amended in the more immigration detention focused defendants, and they added a couple of environmental claims. NEPA, as you've heard about a lot, no NEPA was going to be done before this was constructed. They were moving forward with seeking contracting opportunities and development without doing any NEPA or even scoping. And so for those of us who do NEPA all the time, there's a pretty normal process. It's starting to get truncated a lot now that they've been changing the NEPA rules quite a bit. But generally you have to scope a project and then have public comment periods and disclose information about it. So they weren't doing any of that. So there was a NEPA claim, and then we had a really interesting claim related to the Coastal Zone Management Act, because this is all in, as you can see, this is the site right here. That's the airport, and that's the beach right there. So very, very close proximity to the coast, very close proximity to a lot of species use. There's orca whales that use that area, lots of different kinds of whales, lots of bird species, snowy plover, marbled murrelet. You're in a sensitive coastal zone, so there was, Oregon has, under the Coastal Zone Management Act, a coastal zone management plan, and so anytime a federal development is going to happen or be proposed inside the coastal zone, excuse me, there's a consistency determination process that has to go on between the federal government and the state. And so that was another thing that wasn't going to happen at all. And the state had been trying to ask the federal government, like, are you going to do this, there was no communication between the state and the federal government on this. So the state put that claim in as well. They also included ultra vires claims, which I think are important because those are a little different than APA claims. They're not so much about final agency action as they are about the government doing something that's outside of its statutory authority. So you get different legal hooks with ultra vires. There's a lot of overlap, but there's more of an argument under ultra vires that you can get discovery. And then they still had the helicopter claims in. So by this time it got a little complicated because now there are multiple different cases pending. There was the original Fisherman Wives County, there was the state, and then there was the city of Newport. And then we decided to jump in also, because why not? So our clients at the coast, and then some of our other clients here in Eugene, Cascadia Wildlands, were interested in, watching this, and no offense whatsoever to the state. I'm so glad that they, decided to be aggressive about this and get involved, but the state doesn't do a lot of NEPA in Oregon. I've never seen the state of Oregon do a NEPA claim. I know they've done a few, but not many. And the CZMA situation is different because the state is a party to the CZMA process, but our clients are not. They're sort of the outside public. So we did want environmental plaintiffs to be involved in this case just to make sure that the public's rights and the environmental group's rights and the ecological issues were going to be well represented in the case, especially because this is a really sensitive area, and they were talking about doing this development really rapidly. They did want to open this spring. There were no Endangered Species Act claims in, but we were thinking that there might be an opportunity to bring Endangered Species Act issues in. So we filed a motion to intervene in these cases on behalf of these two clients. I don't have a lot to say as far as what's going on so far in this case, other than the feds have kind of backed off on Newport as a site. They've now filed some declarations saying that, so what happened was the state asked for additional discovery. There was some complicated procedural stuff with consolidating and separating out some of these cases so that there wasn't so much going on with them because there were so many cases pending. And then, so the state and the city of Newport have asked for additional discovery. They wanted to post some more folks at DHS. The feds have filed some decks saying we're actually not going to build at Newport. Never mind. Maybe we were going to do it, but we aren't going to do it now. But they have not been willing to make strong enough representations that they're not looking in the area at all, or that they're not looking on the coast. They're still being kind of cagey about that. There are some rumors now that they're potentially looking south towards Coos Bay and North Bend, and they did oppose our intervention. They sort of at first didn't oppose it, and then now have actively opposed to the environmental group intervention. And so we're kind of waiting to see what's going to happen next. And I think I just have one more slide. Was that it? Maybe that's it. That's it. I did just want to say one more thing before I was done. So intervention is kind of an interesting aspect of this because for us in the states that have friendly state governments who are really excited to do this anti-Trump work and anti-detention center work, there are coalitions of the AG's offices that are working on this, and so they have 70 lawsuits against Trump going at once, and they have teams of lawyers at the AG's office that work on these cases, but they're not usually specialists on immigration or environmental law. So it's great that the state wants to get in, but we do think that there is a role for environmental groups or environmental justice groups or immigration rights groups to intervene. But I think one of the things that's tricky about intervention is you do have to demonstrate that you have a different interest in the state or than the plaintiff group. So that's one thing that we have kind of struggled with a little bit, is really trying to articulate why our client groups would bring the unique interest and the unique litigation perspective or position. So it's great to do the collaboration with the state and with the government, friendly governments like the cities or whatever, but yeah, it can also be good to stake out your own spot and then be able to demonstrate that when you want to intervene and have a seat at the table, because things can always change with the government, and they also don't necessarily know all the NEPA stuff as well as we do. So yeah, so I'm not sure what's going to happen next, but stay tuned. I'm sure you'll see something, and yeah, we don't really trust everything that they're saying, but we're really happy to see that that order out of Maryland, and that's a great. Oh, sorry, I'm gonna say one more thing really quick. 1 minute. The other issue in our case that we're looking at with respect to the Maryland case versus our case is the final agency action issue. So, in order to trigger NEPA, you have to have a major federal action, but you also have to have something that's actually going to be where they make an irretrievable commitment of resources. So you can't just have like tentative planning necessarily to trigger the NEPA. So in our case, that was part of the issue that they filed on a motion to dismiss is, never mind, we weren't really gonna do this. But then you have this chicken or egg problem where I think, like we've heard, they're trying a bunch of different strategies. And so when do you file and when do you jump in and how do you prove that they're actually moving forward has been a tricky issue for us. So I think evidence gathering is really important, and looking at their online ads for like contractors, and anytime they're entering into contracts and stuff like that, I think that's super important evidence for like they're moving. Because once they start moving, they don't stop, so it's like, I think it's that issue of like, how do you catch them at a point where they need to start the NEPA and then get to court like as quickly as possible, which it looks like they did in Maryland really, really well. So, great model. Yeah, that's it.
Thank you, Meriel. So I'm going to ask one question to the panelists, and anybody or any combination of y'all can respond to this. Just want to elevate one issue, and then we're going to spend the rest of the time, I'm sure y'all have questions about this, taking y'all's questions. But I think a lot of the attention right now, and what we've definitely seen in the working group, is most of the resources that are coming in are folks interested in engaging around the warehouses and places where there are like new construction, fully federal owned facilities. And we definitely still need more support there. But as you pointed out, like 87% of detainees are being held in privately run facilities or county jails. And so the vast bulk of existing detention is there. And there are a lot of things happening there. There are, physical expansions happening on those facilities. There are contracts that have expired, and so facilities operating without contracts or contracts that are being renewed. And I know in particular in like Torrance County, New Mexico, there are folks that are considering, is a contract renewal with a private prison company a significant enough federal action to trigger NEPA review and trigger an EIS? So using it in these creative ways, in these, once again, less sexy cases than the kind of big, massive detention center warehouse conversion. So I'd love if anyone wanted to speak to like how folks are approaching or what the angles on those local fights where there historically has been a little bit more skepticism in using these tools. And any of you, I know all of you touched on this a little bit.
I can chime in on it because I think from the organizing perspective, the challenging the jails that have these contracts presents a lot of opportunities for like engaging the public in a way that is really accessible, like showing up to these regular monthly, sometimes more than monthly county meetings or agency or board meetings where you can mobilize public comment, put things on the record, and force the local agencies to the table that then provide records that can be used effectively. Like one of the things that we're seeing in Maine, where I currently live, is like this challenge that came out of the desire to cancel a contract with local agency is now becoming state legislation around mandated language that allows the county jail to refuse ICE because they've been saying they were required under state law. They have to honor these collaborations with federal agencies. And so it was through that county fight that then like bolstered and built up support for a like legislative campaign to address that language, so that like a sympathetic county actually had the tools to fight legally, to refuse and to cancel these contracts and refuse collaboration with federal agencies. So I think there's just a lot of organizing potential in that, although it's not as maybe exciting as new construction or groundbreaking.
Yeah, I see you're unmuted, Michelle.
Yeah, I have a couple thoughts. I mean, I think it's hard to think about, usually what really is a good hook is when there is some significant change in either policy at an existing location. So, for example, in the class action suit I mentioned very briefly in Maryland, that was really a conditions case, like an inhumane conditions, which is a constitutional claim. But you can still, in that case, there was a dropping of a 12-hour policy, a 12-hour hold policy to make it 72 hours with no change in services and with a huge increase in the population being housed there and all the attendant health consequences on those folks. So I think focusing in on the aspects of existing facilities where there are, what is the change being made? If it's a straight contract renewal with no change, I think it's hard to use environmental laws in that way to just challenge ongoing proceedings. But can't just speaking very broadly here, but especially in cases where they're expanding, which we know they are across the board, thinking through what the expansion or additional commitment of resources or change in the contract that increases detention capacity without any increase in services or infrastructure, pressures on infrastructure, wastewater, the surrounding environment that would accompany all of these increases and expansions. That's where, there's like a fruitful angle, usually the more fruitful angle for a challenge under the many laws that we've discussed here today.
And the one thing I would add to that, Michelle, is, and this is just coming out of the conversation I just had with folks in New Mexico, is they're using the documented record of sewage overflows and water issues during the 10-year period that the contract happened to argue that those issues were not considered under the initial environmental assessment. And now there's a contract renewal that requires a new environmental assessment that is for larger, more bodies. So it requires to review those issues. So I think you can use potentially the documented history of abuse that wasn't considered under an initial thing at the beginning.
I think the only thing I would add is just that there's an environmental edge to be made and fight to be made about most of these detention settings, right? The number of times that I've talked to detained individuals that they share with me some aspect of environmental problems with the place that they were being detained. Like at CBP facilities during the Biden administration, a lot of folks were being held in CBP facilities where like the toilet that they were being in, like held in a small cell with like 50 other people, which is kind of like coming up all the time, right? And so a lot of the times, people like me that practice immigration law we just don't know how to fight these things, right? And so we need partnership with folks that understand better to be able to document, to be able to bring these arguments into like conditions fights. I'm thinking about our fight that led to the temporary closure of a facility in Farmville, Virginia back during COVID, right? And in that fight, we needed folks that could like fill the gaps that we didn't, we just like needed infilling on things like ventilation, like what is the use of like chemical munitions, right, used in a facility doing to people when they have some sort of like, there's an airborne illness that's going around. And so I would just say like, yeah, like join the movement by getting in touch with your local immigrants' rights organization, and they will, like put you in touch with the right folks. If you are wanting to do legal research and aren't sort of wanting to like go testify in your local city council or something like that, I don't know, reach out to us and we'll like put you in touch with a fight that might be near you. There's just so many ways to contribute, and it just kind of depends on the kind of work that you want to do.
So with that, I think we have 15 minutes if folks have questions from the room. Yeah, Noah, I see you over here.
Yeah, this is more so a question about using NEPA for a situation like Florida. The defendants, the state and federal government has said that alligator Alcatraz is going to be a blueprint. do you see other ways that you can try to stop these similar state-operated projects using federal environmental laws before they sort of like do the full construction, move NEPA, and now have like this ready built out deportation center?
Michelle, do you need me to repeat those questions? Or can you hear them?
No, I heard it, but I want to make sure I understand the question well, because I actually think the Florida case is pretty unique, even though it was a NEPA case. It has like just the fact that the Everglades is a national preserve, it has its own protections, and a lot of species and wildlife protections and harm, and then the tribe as well, and the tribal reservation land that is also adjacent to and very close by. So there are some pretty unique elements of that. Plus, just this vacillating. We've talked about this among our little group. It's just the government just like the federal government jumping in, saying a lot of shit, and then like backing away, as convenient to them. So, I mean, they said they were committing $600 million to that facility in last summer, and then all of a sudden you get to the 11th Circuit, you get an amazing injunction, you get to let with tons of evidence of harm and testimony in front of the district court judge, and just a ton of work by these attorneys, and then you get to the 11th Circuit, and the fact that there was no document from the federal government that, had committed those funds, or that it just wasn't sufficiently documented, was enough to pause the entire injunction. So I don't know that Florida is necessarily the replicable case, but I guess what is replicable is the fact that there's no NEPA analysis at all, which is what has made it the appeal, and that is the case across the board here. I mean, I don't think any one of us have seen a full NEPA analysis at any of these facilities, whether they're expanding or continuing detention facilities.
I have a question.
But I don't know if I answered that question right.
I mean, I think so. I think with the big fear of the 11th Circuit decision is like whether or not they're going to say that like, oh, it needs to be funding. And so long as funds don't actually exchange hands, once the detention center is fully constructed and operating, what becomes like of NEPA in those instances? Like, I don't want to take up too much of that time, but if like Texas, for instance, wants to build their own deportation center and they construct it in full affront to any environmental review, and they do it under the bidding of some vague direction from the federal government, is there going to be a potential NEPA cause of action, or should something else take place to address that?
I think it's a thing that's worth paying attention to. I think, especially how it resolves in the Florida case, I think it's important in context to recognize that, like, the Florida case was part of a broad schema. There was one in Indiana, there was one in a few other places where the federal government said they were going to do these projects where states built things and then reimbursed. As of right now, Florida is the only place where that has moved forward. They have largely moved on from that schema. Warehouses is now where they're focused. So I think if that revives, it's worth thinking about. Right now, there are no other cases where that seems active or where they're moving on that reimbursement model. And my understanding is that for most states do not have the budget or ability to fully fund the construction of these without federal reimbursement during the process. So it's less of a thing the working group has been focused on outside of the Florida case at this point.
Thank you. Sorry.
Yeah, Ahmed, can I just say that, so they are fighting, so if it's true that the federal government is not going to reimburse Florida for alligator Alcatraz, then you have another issue, which is the state is acting outside of any authority to build a federal detention center, and that's currently what's teed up in front of the 11th Circuit. So I don't think NEPA will ever fully go away. I mean, because if the state doesn't have authority to construct this detention center, it's another avenue to shut it down. But if they did because the federal government authorized it, is that enough to trigger NEPA again? So, I mean, it's not going to go away. But yeah, they're pretty unique. And like Ahmed said, they're changing tactics. The government is changing tactics already.
I just want to say one thing about NEPA also. I think one thing we're really worried about with the NEPA stuff is using categorical exclusions or like short-circuiting the NEPA. So, I think also paying attention to NEPA rulemaking is really important right now because, post the end of CEQ and now each agency is doing its own, and, just watching whatever the jurisdiction is and who's going to be doing the NEPA, who's the lead agency, and then what the what the rules are gonna be in place and whether they have categorical exclusions or emergency authorizations that are gonna allow them to like fast track stuff and just avoid all the public involvement and avoid the NEPA. That's, I mean, we're seeing that extremely heavily in energy development and public lands, and I can see it being a huge issue on this side as well. I mean, emergency authorizations and alternative arrangements instead of doing NEPA, particularly in the face of like the specter of national security, is like a real concern, I would say, for like, it's great if you could say you need to do NEPA on this. It's bad if they say, yeah, we did NEPA and we're done.
And as of right now, DHS claims that they are in the process of developing their NEPA compliance policy, and they currently do not have a NEPA compliance policy. So they rescinded the one that was approved in 2014 under the Obama administration, and when you email them and ask them, what is your NEPA compliance policy, they, at least as of like 6 months ago, they responded back to us and says, we currently do not have one, we will let you know when we have formulated one.
But they can adopt categorical exclusions from other agencies. So they can steal one from corrections or, you know, whoever else and just use that to skip. So it's just, there's a lot of problems with, you have to really watch them closely on the NEPA right now.
I'm a community person. I'm quite concerned about how these detention centers are going to be used. I'm wondering, they sent people to El Salvador and then released them. They sent them to Angola and other places around the world. I'm wondering, you know, who beyond people that they're identifying as immigrants are going to be swept up in this situation, and how do we respond? I'm also wondering about how we just expose what they're doing so that more people resist what they're doing. How do we get the word out there more? I mean, this is a really technical conversation that you guys have been having amongst lawyers, but there's people sitting here in the community. We just want to make sure this doesn't happen to activists, to immigrants, to anyone, because we know that they're bought in with the prison industrial complex. That furthers the incentive to keep building these, but for what purpose? And how people will be affected. Does anybody have any thoughts about that?
Anna, what if you or Penny, what do you want to?
Yeah. I mean, I have a lot of thoughts about that. 5 minutes, so I'll be really quick because I want to hear other questions. I think, you know, yeah, in terms of like who else is going to get swept up again, like in this, a lot of U.S. citizens have been swept up in this already. There was a national security policy memorandum that was issued in the fall, I think in October, that basically criminalizes dissent in such a way that it sweeps up and calls anybody that's doing pro-immigrant work a terrorist, and they're using that to sort of try to charge folks. So in terms of like how dangerous this is, sort of starting with othering the immigrant and then having it grow beyond that and affect, you know, a lot of other folks in the community, it's you know, certainly one of the things that keeps me up at night right now. You asked another good question about how we track this. It's been a, what's the word? Silver edge, sorry, I'm timing.
Silver lining.
Silver lining, thank you. It's been a silver lining of all of the mass layoffs in federal government that there are so many incredible folks who have so much time in their hands. There is something called Project Saltbox that is out of Baltimore. That is, they're going to town on tracking warehouse acquisitions and federal contracts that are being put out to, you know, like, I don't know, order like 3,000 porta potties because they don't have water in one of the warehouses, right? So I think there are so many really incredible tracking efforts that are being led by community members that are concerned. And yeah, I think just, you know, if you're curious or want to plug in more to what's happening in the community, I think certainly there's some good folks to follow in Oregon to try to stay engaged in that, but I don't know anybody else.
Yeah, my two thoughts are that these technical environmental legal challenges opened up really important avenues in two ways. That one is that if you can trigger the public comment period, that's the scoping process, that you can pile in public comment. It gives time to mobilize and educate people. I think it also poses this question of like, who are stakeholders? Are current detainees stakeholders? Are potential asylum seeker stakeholders? And who deserves to be notified? And is there a public needs assessment? Do alternatives exist to this program? I think that's one of the benefits of trying to open up this NEPA plan. Is we have space to like community organize. It also really tees up direct action campaigns, I think, to have a strong legal component to say, no, we're the ones trying to uphold these environmental laws. And so people are like arrested at protests, that you build up your defense to include like a necessity defense or some creative and headline catching community organizing, galvanizing, opportunities by backing up our protests with strong legal arguments.
Let's see if we can get one or two more questions. Anyone else? Let's see if there's anyone else before I go to you again, Noah. Yeah.
I just had a question on one of the earlier slides that was showing a map of facilities popping up over the country. I noticed there weren't any dots on the West Coast, like from Washington State, Oregon, and California, and I was wondering, like, are there any specific environmental laws that lead to that, like that make it significantly harder to try construction on the West Coast? Or is it just like general political opposition?
The warehouse map specifically?
Yeah, I think
so we don't really know. I mean, largely the siting of the warehouses has mostly been due to their proximity to airports and to other facilities to deport folks out. So there are significant facilities being considered potentially in Dublin City in California. So that is not to say there are no facilities being considered on the West Coast, but right now of like the 21 warehouses they initially announced, and they have announced a few others, or not announced, but that we discovered through a FOIA request and lost it, a FOIA suit even, so I shouldn't say announced. There are even some additional ones that have come to light. So I would not attribute them not having warehouse facilities on the West Coast initially in that. They also are trying to move people. It might have more to do even with like them trying to move people out of the Ninth Circuit than anything else, because they're trying to fly. They really are trying to get folks to Louisiana, Texas. Those, it's really where they're trying to move folks from all over the country.
Thank you.
Yeah, no, there's no one else.
I was just going to ask if you folks could plug like a few organizations or projects that people can directly engage with if they want to help build the site fight
Well, I'll first of all just say that if you are an attorney or a law student or attached to a clinic, I help coordinate the environmental law working group within Detention Watch Network's Communities Not Cages campaign, and we have a monthly meeting, and we have a couple of folks. Michelle also helps coordinate it, like directing folks into support roles, so you can chat with us in that role, and we definitely need folks to do fact-finding research in sites, legal research, do consultations with groups on the ground. Even some state attorney general's offices have asked for consultations on some like fact-finding technical environmental questions about endangered species, etc. So those are all things you can do to plug in immediately. I know, Noah, for example, you're attached with a clinic, so I'll just make that pitch right there. And I'll pass it to others.
That's a good one. I mean, I feel like, in our litigation research group for the warehouses, we're so plugged in with Ahmed that when we have a need, we plug in with them. And so if you can get in touch with them, I think follow us we're at NIPNLG if you're curious about the work that we do. We put on just an absolute ton we didn't used to, but we have been doing just a lot of Zoom trainings for accompaniment, for other kind of work, and for lawyers as well. And so, yeah, take a look at our socials if you like.
Are any folks, how many folks are here from the East Coast? New England? Okay. So we're building a lot, and my connections are along the East Coast. So I would say if you're looking at most states in the Northeast have a coalition, statewide coalition. A lot of them are under the NPNA umbrella. I think plugging in with those coalitions is a really good way to make these connections and join the mutual aid efforts and ICE Watch efforts that are going up across the country. because I think those are a really important entry point in relationship building, so that when you do show up and announce an environmental campaign, that there's trust and respect that's developed. So if you're somewhere, I have some cards. If you're somewhere on the East Coast and you want to be in touch, and I can try to plug you with contacts.
I'll take one more and then we'll wrap.
This is actually just a comment, not, hopefully it's okay to say, but at 12 o'clock tomorrow, the federal building here in Coburg is an anti-Newport Detention Center West Coast protest.
That was a wonderful way to end this. Come at 12 o'clock tomorrow at the Federal Building.